Good morning, Your Excellencies, ladies and gentlemen. I hope everybody has found a seat. It's quite a busy meeting, lots of interest, so thank you all very much for coming and expressing interest in this event. My name is Frane Marojevic. I'm the Director of the Office of the OSCE Representative on Freedom of the Media, and I would like to welcome you to today's event, which is organized by our office, the Office of the Representative on Freedom of the Media, together with the German OSCE Chairmanship. As you all know, the topic of our discussion today is propaganda for war and hatred and freedom of the media. As you already know, we are here today to discuss the legal and historical basis for the case against propaganda, human rights and legal implications of propaganda on freedom of the media, and on wider concepts of security and cooperation in Europe. Also best practices to protect media freedom, including the need to protect independent voices, the practice of terminologies related to the phenomenon of propaganda and its effect on the media, and the challenges that propaganda brings to journalism and journalists both online and offline. We are very much looking forward to a constructive debate today on these issues, which will pave the way for our future engagement in this field. And as it is understandable that the topic of propaganda for war and hatred raises many difficult issues and emotions. Therefore, right at the beginning, I would like to make it clear that we are not here to adjudicate or to decide on the merit of individual or particular cases. We are here to discuss the topic and the concepts. And therefore, I would like to urge all the participants, when you take the floor, to refer to specific examples only if you need to illustrate a specific or a particular point. And another point of order, in order to have as many people engaged in the discussion, I would really very much appreciate if you could limit your questions or interventions to up to 2 minutes. That, of course, does not apply to our keynote speakers and our panelists. So I would like to thank you for this in advance. Now I would like to ask the OSCE Representative on Freedom of the Media, Ms. Dunja Mijatović, to open today's discussions.
Thank you, Frane. Good morning, Excellencies, ladies and gentlemen, dear colleagues, dear friends. It is, as always, a great honor and pleasure for me to welcome you here to Vienna, to Hofburg, to the OSCE, to discuss one of the topics that are so relevant for the well-being of our societies, the problems we are facing because of issues we are trying to raise as the Office of the Representative on Freedom of the Media, and also to have an open and frank discussion about all these issues. Let me start by thanking the German Chairmanship for providing all of us an opportunity to discuss and contemplate the issue of relationship between freedom of the media and propaganda for war and hatred. The topic of our today's expert meeting is extremely important for the work of my office, but also for the work we are trying to engage with when it comes to government officials, civil society, scholars, and many others trying to tackle this very important topic. Propaganda for war and hatred that leads to violence and discrimination has always been detrimental to worldwide peace and cooperation among nations, especially in Europe. No wonder that international law directs all governments to ban such propaganda in domestic law and policy. At the time of the Helsinki Final Act of 1975, the main and the most important document that actually established this organization and laid the foundation for the OSCE, the participating states committed themselves to promote in their relations with one another, and I quote here, "a climate of confidence and respect among peoples consonant with their duty to refrain from propaganda for wars of aggression against each other." So this is what 57 at this stage said is so important to them. But what I say as their representative or your representative on freedom of the media, I say wonderful words on paper. But you look at the practice, you look at in the field, and you see a different story and a different response when it comes to these wonderful words. Those words and those promises were broken for the first time before and during in the war in former Yugoslavia, where I come from. In the 1990s, dangerous stereotypes that dominated the Yugoslav state media since the beginning of the crisis significantly increased the feelings of national and religious differences. They contributed to the development of an intolerant atmosphere and influenced people's minds in the worst possible way. Being a citizen of Bosnia and Herzegovina, I have no doubt that the media really did play one of the key and dirtiest roles in the military conflicts in the region of the former Yugoslavia. At the same time, I'm sure that the media were only an instrument of politics. There is no doubt that the real responsibility for hateful propaganda belonged to the politicians. In his book, Forging the War, Mark Thompson wrote that verbal violence produced physical violence and that the war initially started in media. Italian journalist Paolo Rumiz also wrote in his book, Masks for a Massacre, that war was already present in 1988 in the headlines and articles. At the time of war in Bosnia and Herzegovina, many journalist articles were dominated by ideological consciousness and based on execution of political plans rather than professionalism and objectivity. Facts in these articles were interpreted very imaginatively, and they had the form of arbitrary constructions cleverly designed to achieve political interests. There are many examples to point to how media was instrumental in inciting and injecting hatred among people, violence, and ultimately ethnic cleansing. There are many examples, unfortunately, of texts and broadcasts where it can be seen how media was used as a propaganda for war and hatred. Boro Kontić, a prominent journalist and a good friend of mine, who is also here with us today, sitting somewhere, I cannot see him, in order to embarrass him. He's also a director of Media Center in Sarajevo, has been collecting examples of wartime journalism, if you can call it journalism, in the former Yugoslavia from 1991 to 1995. Mostly those addressing warmongering, propaganda, and hate speech. In his 2010 documentary, Years Eaten by Lions, he sent yet another warning and an important reminder on how war propaganda can cause damage to society. He found and interviewed those whose pieces and reports were simply spectacular lies, intended to incite hatred and violence, and who in their reports pointed the finger at individuals or local groups of people who were to be chased out of their town or village, imprisoned, beaten, and killed. Ladies and gentlemen, today, years later, this phenomenon of propaganda jumps to our world straight from those times. Stories of conspiracy theories, tortured children, mass graves, rapes, and mail parcels with heads of insurgents in Ukraine have filled the television screens, all proven by fake testimonies and online videos. For quite a while, I have been monitoring the trend of governmental authorities wherever they own media outlets directly or by proxy, corrupting the profession, corrupting journalism, by scoring high ratings and gaining influence on blood, hate speech, and narrow-mindedness. Of course, the media is also in dire need of self-examination. There is no doubt about this. I believe that propaganda is yet another scar, ugly scar, on the face of modern journalism. There is a need, if you will, to cleanse journalism of fear, manipulation, and routine frustration. In the absence of critical journalism, democracy suffers, and deliberate misinformation becomes the standard. In my capacity of the representative on freedom of the media, I started in 2014 a dialogue that many called Mission Impossible, but I would say it's not accomplished yet, but of course it has to be possible. A dialogue between Russian and Ukrainian journalists to recognize and promote such tools. I'm proud, very proud, of all people engaged in this project and a dialogue that has proven sustainable and plays a role in still very fragile situation and the process in the region. We have had 10 meetings of the Round Table, the latest held just yesterday. So all people that are part of this project are present here, and I once again greet them all. And I commend them on courage and professionalism in trying to achieve some of the most important goals for the future of our societies. In addition, in October 2015, we started another dialogue, which was an idea of this group of people, a dialogue of young journalists from both countries, from Russia and from Ukraine. And they are going to produce joint media products very soon. They are working hard. I met with them last week, and I spoke to these young people that are trying actually to prove what journalism means. They're of course not engaging in politics at this stage as young people trying to become professional journalists, but at the same time they are trying to work based on facts and on fair and impartial information. The aim is, again, to prove that reconciliation is feasible and journalists can lead by example. They can be the ones building bridges, connecting people, but also raising all important topics that are so difficult or even to say painful to discuss nowadays. In late 2015, I presented to participating states of the OSCE and the public a non-paper on propaganda and media freedom. You all have it outside this office. It is a paper or a discussion paper noting destructive powers of hateful propaganda and its roots, causes that must be eliminated. Developed by my office, and it's currently available in English and in Russian, and what I heard also it will be translated to Lithuanian very soon. It offers an in-depth look into the legal and historical context of propaganda to freedom of the media. I believe that ignorance, hate, hostility, and the other consequences of propaganda are imminent threats to journalism and free media. I would like to have this paper discussed here, also among the experts, journalists, governments, and civil society at large. This is the context for today's meeting. Frane already laid some framework for you. I want this to be interactive and open and frank dialogue. The meeting, as you probably noted, brings together experts from throughout the OSCE region to discuss the practice of and terminologies related to the phenomenon of propaganda for war and hatred and its effect on the media, as well as the challenges it brings to the journalists online and offline. With this, I stop here. I look forward to listen to our experts. I look forward to listen to all of you. And of course, I'm at your disposal to discuss topic of today's meeting. Once again, I welcome you all here. You are very important to this discussion, and you are also important in which way the office will continue working in relation to this, unfortunately, very important topic in the 21st century. Thank you very much.
Thank you very much. Now I would like to give the floor to the OSCE Chairmanship, Sabine Stohr, Deputy Head of the Permanent Mission of Germany to the OSCE.
Thank you very much. Dear Dunja Mijatovic, distinguished guests, ladies and gentlemen, and dear colleagues, thank you all for your huge interest in this event, and of course special thanks to those who have made quite a long way to Vienna to participate once more in discussions and hopefully fruitful work on the issue of propaganda here in the context of the OSCE. Our thanks, of course, also go to you, Dunja Mijatovic, and to your team for organizing today's event. The issue of propaganda for war and hatred and freedom of the media remains high on our agenda. Let me recall the words of Foreign Minister Steinmeier last July when he presented the outlines of the German Chairmanship program to the Permanent Council. There, he also touched upon the issue of propaganda. I quote, "Times of conflict, unfortunately, are also times of propaganda and of distorted images. The OSCE should set common standards against these things. Free and democratic societies are much less vulnerable to the virus of extremism, radicalization, and terrorism. We as governments are dependent on the trust of our citizens. Only a government that protects basic rights earned the confidence of the people." End of quote. Propaganda and disinformation put democratic societies under threat. They do not help a government to become stronger, and they do not foster stable relations between countries. Pluralism in the media is not an enemy to societies or governments. It is one of the natural elements of a democratic society. And on the long run, propaganda has never proven to be successful. Today's event is focusing on the problem of propaganda for war and hatred as it is laid down in Article 20 ICCPR and on its relation to freedom of expression as it is laid down in Article 19 of the same document. And this is the obvious link, of course, to the concept of peace, security and cooperation in the OSCE. And you also mentioned it, but one can never quote enough the Helsinki Final Act in these rooms. The Helsinki Final Act itself underlines that participating states shall refrain from propaganda for wars of aggression. Germany very much appreciates the work on this topic that has been done by the Office of the Representative of the Freedom of the Media and by you personally so far. We welcome the non-paper on propaganda and freedom of the media presented and published at the end of last year as a good basis for further discussions and deliberations in the OSCE framework. It contains comprehensive and in-depth analysis of the several international standards on propaganda, of OSCE references and several commitments, and of examples of national legislation and self-regulation mechanisms. It also asks the right questions to define the way ahead, and thus matches with what we have announced to be a focus of our work during the German OSCE Chairmanship. It is an excellent foundation to work on the phenomenon of propaganda. In this vein, we welcome today's opportunity to approach the problem of propaganda with the help of able experts. We want to offer a platform to identify general and current problems of propaganda. We should discuss legal gaps and different views on the application of the terminology. We would like to identify common grounds, and we aim at sharpening our view and increase the common understanding for the risks that continuous disinformation and propaganda cause. I would like to encourage all participants to listen to each other and to engage actively in a way that contributes to the matter of the questions. Thank you once again, and I'm looking forward to a fruitful event.
Thank you very much. As you can see, today's event is also open to the media and is being webcast as well. However, not to disrupt the discussion, I would now ask the camera operators, apart from obviously our webcast, to take a seat so that we can have a much more better view of the rest of the room and an open discussion. And with that, I would now pass the floor to our first moderator, Professor André Richter, a senior advisor in our Office of the Representative of Freedom of the Media, who will take the first panel, which will discuss legal definitions and challenges to propaganda.
Thank you, Frane. Good morning. So we start the first session, which will last until noon, with a short coffee break. There will be plenty of time for discussions, and we welcome discussions from the participants. We have quite a renowned panel of experts. You have biographies outside of the hall. I'm not sure if everybody took these 2 sheets of biographies of the speakers. I will not read what is said there. I will just highlight maybe the most important aspects of their work. We have Wolfgang Benedek to the right of me, who is one of the leading Austrian or European human rights experts, and author of several publications, including Council of Europe book on freedom of expression and internet, published 2 years ago now. We have Michael Kearney sitting here. He is an Irish scholar working in UK at the University of Sussex in Brighton. And Michael has authored a book which is widely cited in the non-paper on propaganda and freedom of expression, which is titled Propaganda for War, Prohibition of Propaganda for War in International Law, published in Oxford in 2007, and which became, as we discovered yesterday, quite popular publication since recently. And the third speaker is Marloes van Noorlos, a professor of criminal law at the Department of Criminal Law in Tilburg, in Netherlands, currently a visiting scholar at the University of Oxford, who did research on hate speech laws in Netherlands, but also in the UK and other European countries. We will change the order of presentations as compared to the agenda, and I request Michael to take the floor first. Michael.
Good morning, everyone. I'm just going to give a short introductory presentation. My intention is to speak relatively broadly about the position that the prohibition of propaganda for war, the place it's situated in broader public international law. My starting point is going to be what I think is a very important point made in the report on propaganda by the representative, which is that in considering the prohibition of propaganda for war and incitement to hatred in international law, that this concept, this prohibition, should be considered as being quite distinct from freedom of expression issues. It's a point to which I fully subscribe, and to try and explain, I just want to give a kind of a general comment on freedom of expression and how freedom of expression exists within international law. It seems to me that as academics, as lawyers, we tend to treat freedom of expression and restrictions on freedom of expression as what in a legal term as a type of a lex specialis, which is that it's a special law that's understood and interpreted almost in isolation from the broader principles of public international law. I think one of the reasons for this is the structure of the provisions on freedom of expression in international instruments like the International Covenant on Civil and Political Rights and in the European Convention on Human Rights, where you have the statement saying we all have the right to freedom of expression, and then you have the restrictions where the state is permitted to place restrictions on that right. So I think us as lawyers, as academics, we look at freedom of expression on the basis of the right and the concomitant restrictions. And I think we fail to do it justice because we don't pay enough attention to the additional elements of international law, the additional human rights that are impacted by freedom of expression issues. I also think most freedom of expression issues are by definition, they're going to be quite contentious, quite political, quite emotive. And I think at the outset, it's important to acknowledge that when we look at decisions from institutions like the European Court on freedom of expression, there does seem to be a lot of hypocrisy and contradictions in those decisions. And just want to make this acknowledgement. You know, one of the examples recently is the European Court has basically said, you know, it's criminal to deny the Holocaust as a genocide, but it's not criminal to deny the Armenian genocide, okay? So you have, from the victim's perspective, from the perspective of different nationalities or identity groups, a very clear charge of hypocrisy can be levelled against the liberal human rights institutions when it comes to how they decide freedom of expression issues. But that's just an inherent part of the debate, I think. I'm really encouraged to see this particular report and the stream of work that the Representative's Office has been developing on freedom of expression and on propaganda for war. The emphasis in the report on media literacy and education, I think, is extremely welcome. As a teacher myself, I realise that this is a very ambitious project, however important it is. It really needs media literacy and education and understanding the media is something that we need to begin at a very young age, and I think we take it for granted far too often. The emphasis in the report also on supporting journalists is particularly important. Just to take one example, I think the manner by which journalists have been targeted from the beginning of the conflict in Syria, where for the first couple of years, at least, it was really difficult to find independent, reliable journalism and reportage on the nature of the conflict and the dynamics of the conflict. And I think that fed into it's one of the reasons that the international community has been so slow or so weak in responding to the development of the conflict there. You know, it's one thing to talk about in this day and age that we have Twitter and we have Facebook, and that you can get a lot of information from activists and from people in Syria coming out, but that's no replacement for responsible, reliable journalism. It's really not possible for most people to decipher and to interpret Twitter or Facebook coming from a conflict zone. On the prohibition of propaganda for war itself, as again it's noted in the report, we have this contradiction, this charge of hypocrisy, if you will, where states and the Western liberal states are quite committed to prohibiting and criminalising forms of speech they consider as constituting incitement to hatred, incitement to violence, but they refuse to support the international legal prohibition on propaganda for war. This is a long-standing position on the part of the West, developed during the Cold War. The reasons given are that it's too difficult, or we don't have the capacity to define propaganda accurately. We don't have the capacity to define the concept of war accurately. So for us to commit to a prohibition of propaganda for war would constitute an undue infringement on the concept of freedom of expression. Now, in recent years, we have seen those very same states, and I'm going to take the United Kingdom, where I'm based, as an example here. The United Kingdom refuses to withdraw its reservation to Article 20 of the Covenant on Civil Political Rights. Its reservation saying that it refuses to be bound by the prohibition of propaganda for war on freedom of expression grounds. Yet, the British courts and the British Parliament have been enthusiastic and fully committed to prosecuting individuals they consider engaging in encouragement or glorification of terrorism. And this, this is something we see across the globe today. I want to take one example of a case, a very important case from the British Supreme Court in 2013. It's the case of Mohammed Gul. Mohammed Gul was a student who was accused and convicted of uploading videos to YouTube. These videos showed footage of Taliban attacks on British forces in Afghanistan. So he was convicted of glorifying terrorism. The reason the case went to the Supreme Court is that Mohammed Gul and his lawyers were challenging the very notion of terrorism in British law. What is the definition of terrorism? The British Supreme Court basically came to the conclusion and upheld his conviction, but agreed with the statement, with his general idea that there is no definition of terrorism in British law, in international law. It's basically a political decision whether to prosecute someone for terrorism or not. This is a significant threat to the very basics of criminal law, the idea that as citizens we should be able to interpret the law and understand what is permissible and what is criminal. When we don't have a definition of terrorism, it's very difficult to know, is my speech, my advocacy of a particular political perspective, might that be interpreted as terrorism and as criminal? So I'm giving that example because it shows how states have taken a very different approach to freedom of expression issues when it comes to terrorism and when it comes to war. The whole incitement to terrorism, the glorification of terrorism, that hasn't really been adequately addressed by advocates of freedom of expression, which goes back to my initial point that freedom of expression exists very separate from other strands of public international law. Just going to make one or two more points before I conclude. The question of propaganda for war, it's not really a freedom of expression issue. The question of propaganda for war is a matter of, it should be a matter of concern at Security Council level, at General Assembly level. It's not primarily about an individual's right to freedom of expression. It's primarily about threats to the maintenance or the pursuit of international peace and security. With respect to terrorism, there's no consensus on the definition of terrorism. What we're seeing is a fragmentation of international law where each state, each jurisdiction is coming to its own definition, its own interpretation. What I see the potential from this report and the work of the Representative's Office is putting back on the agenda. It's been absent for far too long. A need not for states to interpret propaganda for war in their own independent way, but rather to have a dialogue, an international dialogue, hopefully through the UN system at some point, where we can come to some sort of consensus as to what does constitute propaganda and propaganda for war, and what steps, primarily I guess, withdrawal of the reservations to the Covenant on Civil and Political Rights, what steps can be taken to rectify the current situation. To conclude, on incitement generally and on hate speech, we are seeing an awful lot of attention being given to propaganda and to incitement in times of conflict in the area of international criminal law. Hate speech, the role of censorship, media control, cover-ups. Just 2 weeks ago, the Office of the Prosecutor at the International Criminal Court gave her opening statement that a trial that's just beginning in The Hague. This is a case that's been brought against the former president of Côte d'Ivoire, of Ivory Coast, and his lieutenant. So these guys, two politicians, been prosecuted on charges of crimes against humanity. And in her opening statement, signalling her intention of how she was going to build the case, the prosecutor, she really stressed that in developing a political plan and a political policy to target civilians in order to retain power, that these politicians relied heavily and extensively on what she called hateful rhetoric. All of we've heard about the former Yugoslavia, but all the criminal cases on war crimes and crimes against humanity that the International Criminal Tribunal for the former Yugoslavia, the International Criminal Tribunal for Rwanda, and now the International Criminal Court, it's inevitable that it runs through almost every case: propaganda, hate speech, incitement. So if freedom of expression is a human rights issue, if incitement is being developed and interpreted by the international criminal courts, and then if propaganda for war is a broader, more public international law issue, I think where we are as lawyers, as academics, as activists, is we need to attempt to thread each of these issues together to try and make a more coherent understanding of the issue as a matter of general public international law. So I'll just leave it there. Thank you.
Thank you very much, Michael. I pass the floor to Professor Benedek for his comments.
Thank you very much, and good morning to everybody. I would like to continue a bit on the line of arguments we just have heard. Although I would not say that freedom of expression has no role in this respect, but I think one has to see both issues on their own and also in their interrelationship. I would first like to congratulate the office for this nice non-paper. It's a paper in the end. And I think it's very nicely done, and it gives a lot of food for thought. And the purpose of our meeting here today, I think, is exactly to give a lot of thought to these issues and to see what can be achieved through a common effort. Because I'm sure that nobody comes here with the purpose of how can I justify war propaganda, how can I increase war propaganda, and so on. So most likely people are not starting from the idea that this is a good thing. Therefore, the issue is how to deal with it from a legal point of view here in the first place. And we are all aware that it's very difficult because of a lack of a common definition, what we understand by war propaganda, as it is also pointed out in this paper. When we look at the jurisprudence of the European Court of Human Rights, which at least is relevant to 47 member states or contracting states of the OSCE, then we see that it applies a very wide concept of freedom of expression as a pillar of democratic society, and from this it sets also limits to expression which are likely to incite to or result in violence. In the Turkish cases in the end of the 90s, and in particular in the case Özgür Gündem versus Turkey of 2000, which advocated armed struggle and glorified war, it adopted this wide approach, including even speech which is capable of causing violence. And a similar approach was then also adopted in the Council of Europe Convention on the Prevention of Terrorism, where in Article 5, besides incitement, also those incitement which causes a danger that such offenses may be committed is included. So this is a very wide approach, and one could even discuss whether it cannot also be dangerous under certain circumstances. Generally, the case of war propaganda, one would assume that this is related to the incitement of violence, as war propaganda therefore has to be prohibited or persecuted. However, one should maybe also take a wider view that it's not always necessary to incite to violence as such. There might also be other forms of war propaganda which make war more acceptable by not showing what war means in practice, what is really going on the ground, the killings, the suffering, the refugees. And to start with to give an example of Austria, last year, or 2 years ago, we were thinking back of the start of the First World War, 100 years ago at the time. And there was a considerable debate on war propaganda when in 1914 the First World War started, and what Austria, for example, did during that times, how historians look at that time. And when you look at the pictures which exist from this war, then you mainly see heroes and brave soldiers and so on, but you do not see the black side. You do not see the suffering, so to say. And this has not changed too much until today. When we look back in history, then we find this famous saying, which goes back to the Greek philosopher Aeschylus, who said, in war, truth is the first casualty. And this was around 500 years before Jesus Christ. So we should not be surprised if we see similar things today. But we need to think about how to deal with such situations. And this might argue for a wider definition of war propaganda, which takes into account not only the direct incitement to violence, but also what is happening through public relations specialists and companies, so-called spin doctors, the disinformation campaigns, which are observed practically in the context of all wars. And here also the so-called patriotic role of the media needs to be reviewed, or the embedded journalists in certain war campaigns, etc. But I think this will be discussed more in this afternoon. Now, how to distinguish also between the public accountability of states on the one side and private responsibility on the other side? In times of the internet, there's hardly a clear distinction anymore, if there ever was. War propaganda could also include shaping a proper mindset for war by dehumanizing the enemy, which brings us very close to hate speech. And this is an issue which was addressed already in Article 4 of the 1965 International Convention Against Racial Discrimination, dealing with propaganda like racial superiority or incitement to racial discrimination. There is also the danger of overreaction to the prohibition of war propaganda, which Michael pointed out, Article 20, paragraph 1 of the International Covenant on Civil and Political Rights, because it could also, the reaction could also lead to misuse to suppress other opinions, and this respect also to censorship and to putting freedom of expression at stake. And here you can see also the concern by the European Court of Human Rights that such legislation and practice must not be abused to limit democratic debates. And furthermore, also freedom of information needs to be taken into account as part of freedom of expression. Finally, it will be up to independent courts to draw the line, but they have to be transparent in balancing the often conflicting considerations and applying the principle of proportionality. Often we see courts struggling with the concepts and in the particular context in which they are operating, where maybe also patriotism may be expected from them by their respective governments. Let me say a few words also on new challenges related to the new technologies, in particular the internet and social networks. These new technologies provide new opportunities to get better informed. Today we have citizen journalists, so we can know much better what is going on. At the same time, they are also used to manipulating public opinion. And we can see, for example, comments in newspaper articles or in articles on the internet, which are often indeed inciting to violence and justifying violence. Such comments, in principle, are welcomed as a participatory approach, I mean the possibility of making comments, but they are often misused for defamation and hate speech or even propaganda for war. So this raises the issue of how to determine the limits of freedom of expression online, which again requires careful balancing. In particular, in a time where freedom of expression online is also under attack. And this could be aggravated by using the situation as an excuse of fighting war propaganda and hate speech, but at the same time suppressing freedom of expression. In this respect, also the liability of internet platforms comes up. And we have recently had two cases which came to different conclusions in this respect in the European Court of Human Rights. One was the Delphi case, which found that the restrictions taken by the government of Estonia in this case were not a violation of freedom of expression. And then the very recent Cengic case of December 2015, which dealt with blocking YouTube by Turkish authorities and which was indeed found a violation. Sorry, this was not a liability case. This was a freedom of expression case. Now, the other case was the recent Hungarian case only weeks ago, where the court found that there was no liability of a non-profit self-regulatory association of internet service providers and an internet news portal in Hungary for vulgar and offensive speech, because the Hungarian courts had not carried out the proper balance between freedom of expression and the right to respect for commercial reputation, and the injurious nature of the comments were not leading to or not including incitement to violence or hate speech. So we see again this standard being used by the European Court of Human Rights. Also the issue of commercial interest in this respect. So this means, translated to our topic, that incitement to violence and the existing of hate speech is a crucial aspect for findings of the European Court of Human Rights towards a violation, or allowing restrictions of speech. Now, how to deal with this? There is the repressive approach by law, and I think this is also necessary. And there is maybe the enabling approach by self-regulation, which is also pointed out in the conclusions of the Office of the Representative on Freedom of the Media as the preferable approach. And I think indeed that independent agencies and strong press councils can do a better job than just legal restrictions and the respective enforcement. Anyway, we will always also depend on an educated and independent judiciary in that respect. This brings me to a short look at the Austrian situation regarding hate speech. In Austria, we have just had a change of the law in January of this year, in which the law on hate speech was strengthened. And I would like to mention also in that context that Austria has not implemented fully Article 21, the prohibition of war propaganda. We have even not made a reservation. We have simply ignored it, it seems, and only implemented Article 22 regarding hate speech. And here, Austria has made it very clear that hate speech, when it incites to violence against particular groups, and they are identified in particular as, for example, churches or religious communities, and any other group defined by race, color, language, religion or belief, nationality, national or ethnic origin, sex, disability, age or sexual orientation. So any incitement against to hate or violence against such groups is prohibited, in particular if this is a public incitement open to many people. I would also like to point out that in Germany we do have an explicit prohibition of war propaganda when it comes to aggressive war, incitement to aggressive warfare. So you see there is a difference in this respect. Finally, I would like to point out, and I think I will have opportunity to say more on some other issues, that we need to think about what are the possible instruments. And here this report contains a very interesting toolbox, what could be done. And I think it is right in saying a major preoccupation has to be to strengthen greater resilience of the media, but also of the public against war propaganda and hate speech. And this can be done in many ways, and we have heard the example of Dunja Mijatović bringing together journalists from both sides, creating better understanding, strengthening media pluralism, strengthening objectivity. But I think as a lawyer also we need stronger watchdogs. And I think this office is one of them. And there need to be others, also in the civil society sector, like international media associations. In the Council of Europe context, it's maybe the High Commissioner on Human Rights. And maybe we need more institutions or approaches to establish the truth, what really has happened. And here we can see from the United Nations that there are missions of inquiry, that there are fact-finding missions being operated who look what really has happened on the grounds. And I think maybe this is also a way to deal with particular situations in establishing such independent commissions who have the purpose of establishing the objective truth as much as this is possible. And this can then also be a basis for educational efforts on how to do better. And I will leave it with that and come back maybe later with some other ideas. Thank you very much.
Thank you very much. Our speaker is Marloes van Noorlos, and I think that that will be the last speech during this session, and then we'll continue after the coffee break. So you have all your time.
Thank you very much, and thank you for the invitation to the Office of the Representative. Also, thank you for the thoughtful comments in the paper. I think we've all learned a lot from that already, and I will also come back to it in my presentation. I will focus on criminal law. That is my field, and that is also a very interesting field because we are talking about a repressive form of law, a coercive form of law. So that is very important here. When do we want to use this form of law? There are different types of criminal offenses or obligations to criminalize behavior in international law. Of course, we've already heard a few of them, and they are related but also different. So we have the war propaganda obligation to prohibit in Article 21 of the ICCPR, incitement to hatred, obligation to prohibit, Article 22 ICCPR, the incitement to terrorism issue in the EU and the Council of Europe instruments. We also have obligations to criminalize this. But a very special form of law is the prohibition of incitement to genocide, because this is actually an international crime that leads to international criminal responsibility. So that's a very special form that I will come back to. And because it's an international crime, there are also special, very strict requirements for it. And then there are also laws that are related to hate speech, but it's not exactly the same. These are the so-called group defamation laws, where we don't prohibit speech because it may lead other people to get a negative image of the group and to start hating, discriminating, using violence against them. No, we want to prohibit certain speech against groups just to protect the value of equality and to protect these groups of people from defaming, insulting them, from violating their dignity. So it's just a little bit of a different focus than hate speech as such. And related to those group defamation laws, some states also prohibit blasphemy, for instance, defamation of religions as such. And that already gets a bit more problematic, but that's a different discussion that I can't go into today. So there's a whole line of different types of expression that we have to take into account, although our focus today is, of course, on propaganda for war and hatred. Even within European states, not only in the US with its quite distinct freedom of expression ideas, but also within European states, there's quite some discussion about whether the criminal law is always a good instrument to deal with such speech. And when we talk about freedom of expression and propaganda for war, it's of course quite important to note that much propaganda is actually issued by states themselves, whereas the right to freedom of expression is of course an individual right against the state. So it would be easy to say, well, then freedom of expression apparently does not have to play a big role here because we don't need it. We have to protect individuals, not states. On the other hand, it's also a huge dilemma because, as the paper also mentions, propaganda for war and hatred in our current societies can only really be effective when governments control the media and actually support hate speech. So when governments have a big role there, but governments are also the ones in charge of those criminal laws on hate speech and propaganda if they are in place. So they are also the ones policing the public sphere there. So how can we expect them to use them in these situations in a non-hypocritical manner? That's, of course, always the dilemma there. It's very easy to misuse these laws as well. So we have to be careful with them. First of all, because of the potential for misuse, they often target quite broad type of speech. Hate speech laws, propaganda for hatred can be described in such a broad manner that sometimes it can be misused. Secondly, speech is always a matter of context. even terrible types of speech like incitement to genocide. When we look at the case law of the International Court for Rwanda, for instance, we also see there's always a contextual element in it. And that also means, I would say, that freedom of expression should always be a consideration, even when we are talking about terrible types of speech like war propaganda, incitement to genocide. It's still always a matter of context, and you always have to take this into account and make a proportionality test when you are dealing with criminal law. I already said there are these different types of speech, these different types of prohibitions, and they all have problems of definition, which is very important in criminal law. Laws have to be clear, lex certa. People have to know what is a criminal offense. Words like propaganda, also hatred, incitement, they are interpreted in different ways in different countries and systems. It's important with such prohibitions to look very carefully when you draft them and when you use them as a state. What purpose does the prohibition serve? And is the offense formulated in a way that we can actually serve this purpose? For instance, if you want to protect against direct harm, protect against speech leading to violence, how do you formulate the law exactly so that you don't cover also a whole range of other speech? Also look at criteria like intention, mens rea. That's very important here to formulate that in a strict manner. And how direct should the speech be? Do you require that the speech has a potential to cause harm, has the potential to cause imminent harm? Well, how direct this link should be, of course, depends on the type of law and what you want to achieve with it. Of course, the broader it gets, the easier it is to misuse. When we are talking about definitions of propaganda, of war propaganda, it's interesting indeed that we have already heard many Western states haven't criminalized it because of the problems of defining propaganda and war. The same is true for my own country, the Netherlands. It was decided not to prohibit it for reasons that it would be too difficult for the Dutch judiciary then to define when there would be an aggressive war as prohibited by international law. The judge would be brought into a very difficult position there, and also political ideology would play too big of a role, which as Michael Kearney already said, of course, is exactly the problem with the current incitement to terrorism cases, which also the Netherlands is very happy to prosecute and to deal with. I think there the problems of definition and political ideology coming in are even bigger than for propaganda for war. So there is an incongruency there. But anyway, when we talk about the prohibition, the obligation to prohibit in Article 21 ICCPR, there are different messages about its scope. How broad should it be? How should we interpret this prohibition of war propaganda? How direct should it be? There are different messages about this. And the paper mentions several aspects that we could take into account. For instance, when you reduce multidimensional phenomena to simple issues, when you create an enemy picture, manipulation of facts, appeal to emotions, these are all very important to take into account, of course, and at the same time the paper also says it's especially problematic when it's systematic, when there is repetition in it, when there is not enough room for counter voices. So that already indicates that, of course, states should not, deal with any manipulation of facts by criminal law. That would also be problematic, because the state would take on a role of distinguishing truth from falsehood, which is a problematic task for the state to do, to tell us what is true or false. So whether the criminal law is a good way to deal with these issues, you can doubt about that, because criminal law deals with individual instances, individual expressions, and we are talking here about a whole range, a whole systematic process, a gradual process leading to a certain situation. So who are you exactly going to hold responsible there? There are some dilemmas there. Then, as I said, context is always key in these cases. There must always be a balancing act. You have to look at the internal context. For instance, look at the expression within its context, within a book where it is set, for instance. Look at what reasonable possible interpretations there are of that expression. What do we make of it? What do other persons make of it? Then we have to look also at the external context, especially if there is already a war going on. Then, of course, it will be more easily justifiable to prohibit speech. It will also be more difficult to prohibit speech, because who is going to do this if the war is going on? But it's also more easily justifiable because the whole situation has changed, and expressions can more easily lead to certain violent results once there is already violence. And the marketplace of ideas that we are usually talking about when we talk about freedom of expression, this so-called marketplace of ideas, I don't think it ever works perfectly, but especially in conflict situations, of course, it's very difficult. Counter voices may not be available anymore. So it's certain speeches become particularly dangerous. These kinds of contexts can and should be taken into account when judging on hate speech and war propaganda cases, I should say. Think, for instance, of a case in the Netherlands where the question is whether antique shops can sell Hitler's Mein Kampf. And then the question is, of course, can you sell it at all? Can you sell it with a scientific introduction going with it? These kinds of questions already show that context is important, even with terrible expressions like these. So the ICTR has also made this clear, that context can play a role. Also, the other way around, context can be disculpating, or it can make an expression even more worthy of criminalizing, so to say. So, for instance, in the context of Rwanda 1994, a phrase like "go to work" had a very particular meaning, a terrible meaning at that time, and it actually led to situations where people were being killed. Of course, the same neutral sentence in a very different situation has a very different role, but that already indicates that context can also make that an expression should be prohibited, because if you know the context, you know what it means there. And the ICTR has also taken quite a nuanced view, saying, well, we shouldn't look at the expression as such, but we should also look at the cultural, linguistic content, the affiliation of the author, at the audience, how the message can be understood by the audience. All these types of factors play a role in determining whether an expression should be prohibited, whether an expression could perhaps lead to a certain type of harm. So as I said, also the political and security situation plays an important role here. And to come back to what I said in the beginning about laws always have a certain potential for misuse, people often don't realize that even well-meant hate speech bans, like the English law on incitement to racial hatred, even these laws that are meant to protect minorities, even they can be used the other way around to protect the dominant groups and dominant ideas against minorities. For instance, that UK law was used for the first time actually against a black consciousness activist. So, and in many African countries, journalists' committees have also noted how laws that may be well meant to protect against raising too much ethnic consciousness in politics, protecting against ethnic hatred, these laws can also be used to curb political opposition. So they may be well meant, but they can also be used the other way around, especially if you use broad concepts like national security or public order in the law. That can easily be used to protect the dominant groups against vulnerable minorities. These laws are then sometimes applied like the glorification of terrorism laws. They can be easily applied against the so-called state's enemies, like the terrorists, which is then interpreted very broadly sometimes, rather than being used to protect minorities. And it's interesting when we speak about these incitement to terrorism laws that are so popular nowadays, we see a sort of intermingling between past, present, and future. So glorifying certain acts in the past, using certain symbols of the past is sometimes prohibited with the idea that this might in the future lead to new forms of violence. And this, here again, a very deep contextual assessment is extremely important because it can also be a means by the state to try to protect its own vision of history against the visions of others. How to conclude, how can we mitigate this risk of abuse? I mean, it is there. It's not to say that we should not have these laws at all, of course. But the practical application of these laws is in the hands of prosecutors, of state organs. Eventually, judges have to decide about them. So, of course, it's extremely important that all these organs are independent, as well as lawyers, and that threats to the independence of these judges, of prosecutors, etc., that they are adequately addressed. That is even more important than having the laws in place, is to have the right institutions in place to deal with them. And even if you have those very good independent bodies, which I would say in the Netherlands we have, even then there will always be a natural tendency among states' organs to prohibit speech that comes from their enemies, so to say, and to protect the dominant groups in society from speech by terrorists, for instance, but not to look at forms of propaganda that may be issued by their own organs, because it's much more difficult to identify it when it comes close to the goals that you actually promote. So there's always a risk of hypocrisy, but we can try to deal with this, and I think freedom of expression is indeed our ally here, as the Office of the Representative beautifully mentions in the report.
Many thanks. We'll now have a short coffee break, and I encourage everyone to come back in 15 minutes. and take only short coffee. Don't attack the speakers during the coffee break. Don't challenge them.